first to welcome you on this Saturday morning and then very quickly and briefly lay out the intentions and objectives of this session. We know we had a very tough time in Sri Lanka for media, and everybody wanted a reform. That's why there was a political change on 2015, January 8. Many of us here have contributed to that change, not on a political platform, but on a democratic platform. We need democracy. We need reforms. What we realize is there's a vacuum. Vacuum in the society, vacuum in the media, and vacuum in all sectors of stakeholders in Sri Lanka. When we were trying to bring some changes to the system, we realized it confined to a couple of people. We were isolated. We were alone in the fighting for better laws and legal reforms in Sri Lanka. So we could not, I think, the commitment of the government is still there. The deliverability is in question with the government. Especially when we are facing election year, I don't think any government would take that risk of reforming the legal regimes. But we did not give up the fight, the struggle from the civil society. We are still continuing. So this effort is to build awareness and also to get commitment from the professionals in the system, specifically from the legal professions. So when we discussed this matter, when we had some lengthy discussions, Mr. Jagat Vikramanayake volunteered himself with a team of lawyers who are committed and who are really willing to help us in this process with two objectives. One is to build a group of professional legal practitioners to be with us and to fight for a better democracy. Number two, to get better awareness among the society, especially among the journalists, about the legal regimes in Sri Lanka. So this is a short story about history, and this is the very beginning of that process of getting all the stakeholders together, specifically the lawyers, academics, journalists, and human rights defenders to talk about not only about the media, but the whole gamut of freedom of expression and the media, legal regimes in Sri Lanka. Again, a warm welcome and expected to see good proceedings, very healthy discussions. And with that note, let me finish my small welcome remark and thank you very much.
Good morning, members of the all-male panel and the participants from all over the country. And I am very glad to be here on a topic, to discuss a topic which is very close to my heart. And also, this is part of my profession to engage in this particular area, because not most of the lawyers are keen to get into this non-lucrative side of the practice. Freedom of speech is something that you discuss from different angles. It may be political, legal, academic, and so on and so forth. And the genesis is found in historic texts, and someone can say it originated from one region or one religion or one segment, but be that as it may, when it came to modern liberal thinking, then Voltaire's basic statement that we all, of course, we have not forgotten yet, has been a driving factor of so many activists in the world. Voltaire said, I disapprove of what you say, but I will defend to my death your right to say it. Now that was the basis of so many international jurisprudence cases. And also we have seen how that thinking, line of thinking has influenced the modern freedom fighters. There was also a debate on right to information. Of course, the law has now been passed. That is after a huge struggle by journalists as well as civil society. And finally, even the 2015 changes, one of the demands of the people is to introduce freedom of information law. The power of media to create and destroy fundamental human values comes with greater responsibility. Those who control such media are accountable for its consequences. So now this trial is called the media trial. Probably you have seen this one of the most read books written on, edited by a group of academics and journalists, how important that those findings are. So that I think we need to understand. In a multicultural, multi-ethnic society, when the media is crossing the border to incite crimes against groups, against ethnic groups, against religious groups, minorities, and so on and so forth, then you have another responsibility. And media is not about the law. Media is also subject to law, and we think that only president is about the law. No, not about the law. People are also not about the law. We need to understand one principle in constitutional law, which we misread. We believe that under the constitution, the three organs of the state, is the executive, the president, the parliament, and the judiciary, and the state entities are not above the law. Like parrots, we say that. So they are not above the law. But don't forget that people are also not above the law. They are also expected to respect the constitution. That is the most important thing.
Thank you, Mr. Vadiyamuna, for the thought-provoking speech. I thought I gave crash and introduce Jafar. Specifically, Wahid Jafar has expertise on freedom of expression, human rights, and also he's an expert on ASEAN. So we invited Jafar to share his experiences and knowledge with us today.
Good morning, everyone. His and Her Excellency, thanks for having me. So, how the political background in Indonesia during the authoritarian regime mentioned by Mr. Rangga, how the Suharto's as a dictator, as a military regimes, authorized of the Indonesian peoples with strong regulation and strong of law. For first 30 years, the New Order's authoritarian regimes in Indonesia had been in power from 1967 until 1998. And before it eventually failed due to various pressures about the financial crisis in Asia, student movements, social chaos, and internal disputes in its regime in the main period of the 1998. During the Suharto era, this military regime has conducted strict control over information, as shown is the measure to restrict freedom of expression, freedom of speech, and freedom of press. And at the moment, the government banned the dissemination of the number of books. We have the law to book bans to be suspected as spreading communism in the country, regulating media permit as well as throttling the media criticizing the governments, the media bannings, restricting the freedom of assembly, including the establishment of the journalist organizations, other than established by the government. monitoring all comes up and general meetings and reimbursements to the speakers or anyone involved with the meeting. The long history of the human rights violation further became the basis to endorse the bills of various laws, including the amendment of the Constitution, 1945, which specifically granted human rights protection, postponed the new order. It is expected the new law will comprehensively fulfill the rule of law principles, not only become the reference of rule by law action. So in the Suharto's era, the government's action side based on the law, but just in rule by law, not as a rule of the law. How about the guarantee of freedom of expression in the new constitution or after the amendment of the constitution? We can find at the 3 articles in the Indonesian Constitution, at the Article 28, the article side, the freedom to associate and to assembly, to express written and oral opinions, etc., shall be regulated by law. At the second, at the Article 28 E, on the paragraph 3, said, every one person shall have the right to the freedom to associate, to assembly, and to express opinions or their opinions. And the strongest guarantee we can find at the Article 28 F, that every person shall have the right to communicate and to obtain information for the purpose of the development of his or herself and social environment, and shall have the right to seek, obtain, possess, store, process, and convey information by employing all available types of the channels. It is refers to the Article 19 at the International Covenant of Civil and Political Rights, and also refers to the Universal Declaration of Human Rights. And how about the initial point of change with the legislation reform in Indonesia, especially the press freedom? In 1999, the government and House of Representatives issued law number 39 on 1999 on human rights, which materially reflected various kinds of international human rights instruments, within which the protection of freedom of expression is guaranteed. And the law, followed by the deliberation of human rights law, was further followed by the Court of Law number 40 on 1999 on press, which became the pillar of press freedom guarantee in Indonesia. So after the law was born, there is no criminal of press in Indonesia. On 2002, the government and House Representatives issued law on broadcasting, the number of 32 on 2002. This regulation do not only regulate the private broadcasting, but also the public one, or state-owned, and community broadcasting. It is currently in the amendment process in the parliament, in which it to respond to broadcasting digitalization, as well as to endorse the special law on public broadcasting. But the law allegedly as a part of the liberal process, because it is a part of the deregulation of the broadcasting in Indonesia after the pressing from the international financial institutions like IMF, etc., World Bank, etc. And in 2005, the Indonesian government ratified two main human rights covenants, International Covenant on Civil and Political Rights, and the International Covenant on Economic, Social, and Cultural Rights, which strengthen the guarantee of the protection of freedom of expression. And based on the ratification, has strengthened the promotion of issuance of the law on public information disclosure. It is the long struggle from the civil society and also the journalists from 1998 until 2009 to endorse the public information law. All the dispute of the press products, the news or news content, can be settled via this institution or via the press councils. Law of Broadcasting has given mandate to establishing broadcasting commissions, an independent body functioning as regulator and monitor of the broadcasting. The institution was established until at the provincial level. Unfortunately, the selection of the members is from Parliament, which is often interfered by the interests of broadcasting media owners using the political hands in the Parliament. Because in Indonesia, the leaders of the political party also the chair of the biggest media. And Indonesia also has the problems with the impunity of the journalist murders. We have the 12 cases of the journalist murders, which until today still become impunity. There is no perpetrators bring to the court to accountability of the law. The cases are of the murders of Fuad Muhammad Sofruddin, or Udin case, the very famous case in Indonesia, on 1996, Naimullah in 1997, Agus Mulyawan, Muhammad Jamaluddin, Ersa Siregar, Harlianto, Adrian Sahmat Rais, Wibisono and Alfred Nirulawan in Papua on 2010. All the perpetrators have not yet been brought before the trial until now. It is the legacy of the violence of unity.
The defamatory material requires publication. In our law, as this case says, it is necessary to allege in civil action for defamation and to prove that the statement complaint was published to a third party. This particular judgment is important because it refers to various juries. It refers to Macaron, which I cited earlier, which I didn't cite for lack of space, but it refers to the other juries, and it definitely gives the law of this country, which says without publication you cannot go and file a suit for defamation. When it comes to fair comment as well, the same proposition applies, and in this case, the Times of Ceylon, DeCosta versus Times of Ceylon, also states that there can be an element of fair comment, but it also needs to pass the threshold of public interest. This is a case where the defendant was successful in the Court of Appeal, where the judges held that the concept of fair comment will apply, and he is not subject to damages in the defamatory suit.
Parliament privileges. This is also when we use media, when we practice the journalism, we have to think about Parliament privileges and the content of courts and sub judice rule. There are, according to my understanding, there are two types of defamation. So one is libel defamation, that's written down things, and then slander, that defamation, that spoken defamation, that verbal defamation. And what consists of defamation? Seneca very detailed this section, but I also like to mention that constitutes. One is that statement should be defamatory, and it should be against or aim to the plaintiff. That one should have be publicized. Without the only the statement is not, we can't suit the defamation case, because statement should publicize. Then what are the successful defense against defamation? In generally, consent. The plaintiff has consent to publish this, then defendant has some chance to litigate the case. And second one is justifiability. The defendant can prove there are any justification to publish this article or program, they can mitigate.
As you know, we are going to be discussing legal impediments to the freedom of expression in Sri Lanka. So we have an eminent panel here today. On my left is Mr. Chanaki Jayadeva, and on my right, Mr. Senani Dayaratna, both attorneys at law.
We are the democratic, socialist Republic of Sri Lanka. We are a democracy, no doubt. We are a socialist country, no doubt. No one knows what that is. In fact, I asked a member of parliament from the JVP, how do you mean? He did not know. But nevertheless, it's there in our name. But above all, we are a republic. A republic is the rule of law. Democracy is the rule of the majority. There is a difference. The rule of the majority, which is democracy, will never trump the rule of law, which is above everything else.
Privacy rights in the news. There are two major questions that I've come up with. First question is, does the media, even though they obtain consent from a group, like following stories with the police and paramedics, do they have a right to enter into premises private people? Now we know recently we have seen in Sri Lanka also, the moment you get a breaking story or a story that deals with private people getting caught for criminal offense, the media goes with the police. If you can recall, recently there was the biggest drug haul which was captured in Sri Lanka. I think 100 kilograms of drug. We saw when the police went, the media also went with them. And they photograph. Of course, they smudge the images of the people. Now, technically, what has been, we don't have cases of this nature in Sri Lanka. I took these positions from cases in other countries. They have held, you are invited to, you can report on that. But like the police or the firefighters or the paramedics going to a crime scene or to arrest somebody, the media does not have the right to go and invade because of the news value of the story into a person's private premises or his office and take visuals of all those things and put on television. I know it happens a lot here because probably we are not aware of that, because if we had privacy laws, if we recognize principles of privacy laws, those people can sue them back, because just because somebody is being arrested or suspected of some kind of a crime, he's not guilty of it. So his privacy rights, his face is shown, and so much of damage can be done to that person's reputation. Second question is whether, this is the flip side of the coin, would be whether you can publish in public interest a set of facts, maybe a report, which is about somebody where some people are involved. We'll say a report by a government about some kind of a institution or some kind of an issue that has been made, whether you can publish it wholly, including the people who were discussing that. In that situation, most cases have held across the globe that yes, if there is sufficient general public interest in publishing that report along with those people's names and their positions, yes, it can be allowed.
So this session is about media regulation and freedom of media freedom.
Why the broadcasters are licensed? And okay, in the case of press, you don't need to have a license. In Indonesia, you used to have a license for publish a newspaper, and you have to renew it every year. That was during the Suharto's time. My colleague from Indonesia might say why Indonesian press was forced to behave as they used to behave during the Suharto's time, because so Suharto did not renew the newspaper if they were overcritical about the regime. So we don't have, fortunately, in Sri Lanka, anybody can open start a newspaper just with the registration and publish it, and there is no need to license. Now, in the case of broadcasting, you need to have a license, and in any country, that's a legitimate requirement, because you use a scarce public resource, which is a spectrum. This is the primary rationale for the regulatory broadcasting. But of course now some people have started arguing that this is no longer valid. The broadcasting can be done through the internet and all other things. But I think this argument is still valid because they use a public space, a spectrum, which cannot be used by everybody else. You have to select number of people who can use the spectrum for broadcasting. So by virtue of this selection, this becomes a privilege of certain limited number of people. So they cannot use it as they wish. They have to use within some agreed norms.
පහුගිය කාලේ ඔබ දන්නවා මාධ්‍ය ආයතන ගිනිතිව්වා මාධ්‍යකරුවන්ට පහර දුන්නා සමහර මාධ්‍යකරුවෝ ඝාතනය කරා යාපනයේ මාධ්‍යකරුවන් 20ක් පමණ මරණයටපත් වෙලා තියෙනවා එතකොට මේ ඔක්කොම සිද්ධ වුණේ අර මාධ්‍ය නීති ඔක්කොම තියෙද්දි ඒ මාධ්‍යකරුවන්ට බලපාන සහ පුරවැසියන්ට බලපාන සියලුම අපරාධ නීති තියෙද්දි තමයි මේ ටික සිදු වුනේ. දැන් පුරවැසියට වැඩි විශේෂත්වයක් නීති රීති පිළිපැදීමෙන් මාධ්‍යකරුවාට නැහැ. එතකොට පුරවැසියා යම්කිසි විදියකින් තමන්ගේ නීති ක්ෂේත්‍රයට විරුද්ධව අලුත් නීතියක් ඇති කිරීමට පක්ෂව හෝ ක්‍රියා කරනවා නම් එතනින් යම්කිසි වෙනසක් තමයි සිදු වෙන්නේ. ඒ වෙනස සිදුවීම සඳහා මුලින් සිදුවන සිද්ධි ඉතාම ප්‍රචණ්ඩ වෙන්න පුළුවනි. එහෙම නැත්නම් සාමකාමී වෙන්න පුළුවනි. එහෙම නැත්නම් දෝෂාකාරී වෙන්න පුළුවන්. කොහොම වුණත් ඒ ක්‍රියා පටිපාටියෙන් තමයි වෙනස් වීම ඇති වෙලා තියෙන්නේ.
When we work with a lot of school children, it's a relationship practice that we share intimate images. But the problem is not the sharing in a relationship. Problem is when the pictures or the videos are shared without the consent of the person with other people. So when we dig into the issue, this is what CERT put out. There is an organizer. So there are various reasons that the girls may share nude pictures to boys. So there are also various reasons that boys share with other boys due to self-esteem, due to peer pressure to become popular or to take revenge. There are a number of reasons. And the boys share it with smaller groups, and the smaller group, from the smaller groups, it goes to the organizer, or from the smaller group, it goes to larger groups with say 5,000 WhatsApp groups, and then it goes to the organizer. Then organizer gets the pictures, and organizer directly gets in touch with the victim again, and under threat of blackmail asks for more pictures. So that's how it has become an industry where the pictures and the videos that were shared in trusted relationships are being exploited. When it comes to support, there's less support because you are a woman and you have done something wrong, you've got naked, you have sent a picture to somebody else, so you are the perpetrator. But no, you're not the perpetrator because these are consent. When you share a picture with somebody with consent, that's not a crime. But when somebody violates that, that is a crime.
80% of the social media is Facebook, Instagram and WhatsApp, which is owned by Facebook. And in the morning today, I saw the news saying that Facebook has now come up with a plan to integrate all these messaging services, Instagram, Facebook and WhatsApp, into one platform, which means even though I do not put my mobile phone number in Facebook, it will be in WhatsApp and it will be interlinked. So the convenience I have, some argue that it's a utility and it's free. And for freedom, that freeness, have all your data intact. So where is the solution? I don't think that any legal system would be able to come up with solution to this fast-paced technology. All we can do is and hope that people will be more comfortable with this because that is the way to go. Because you can't ask people not to go online.
The conference today we had on media and the law in Sri Lanka. So we tried to understand the law relating to media. So at the opening session, the welcome address was delivered by Dr. Ranga Kalansurya, and he pointed out certain important matters relating to media and the law. He briefly introduced the history of media reforms. Then Dr. Kalansurya introduced the guest speaker today, Mr. Jafar from Indonesia, and he shared his experience in the media reforms in Indonesia, especially the situation after the military regime, the legislation reforms, and the public information law, establishment of independent institutions, Press Council, Broadcasting Commission, Information Commission. So a lot of things that we could take examples from their reforms. Thereafter we commence our conference with the first session, that is the defamation and media. So this is a very important session as far as the Sri Lankan legal system is concerned, because we know that we abolished the law relating to criminal defamation. Now we have only the civil defamation. That is to say, a person who is complaining of a defamation can only file action in a civil court. Here, under this session, the points that we emphasized were that what constitutes the civil wrong of defamation, legal requirements for a suit of defamation, parties to a defamation action, defenses in a defamation suit. The most important thing, how media should play its role in the situation of defamation. Whether we should report everything that comes in our way, or whether we should concern about the individual and the defamatory aspect of a news item. Then Mr. Jagat Leonarchi, attorney at law, covered the areas of parliamentary privileges, contempt of court, and the types of defamation, that is written or oral, and what constitutes a defamatory statement. Then the offences related to media. Then Mr. Senani Daratna, attorney at law, covered the areas of freedom of expression, rights in constitution, contempt of court, and parliamentary privileges. Mr. Shanakya, my good friend, he covered the areas of privacy of issues on new media. Privacy is not a right in Sri Lanka, as it's not a recognized right. A person's privacy is not a recognized fundamental right or recognized under any other law. Then we discuss how in certain situations, when there is an emergency situation, the media, the journalists have blocked even the emergency medical assistance. So in those situations, where do we stand? What is the policy with regard to the conduct of journalists? We focused on media regulation and freedom of media. There we try to understand that what do you mean by regularizing media? Are we trying to put media into a kind of a four-corner box and ask them to act within that box? Or what do we mean, or what do we expect by regularizing media? Regularization of media is to ensure free and fair media to protect the public trust. We understood that airwaves are public property, so you have to, when you are using airwaves, that is public property, there should be some responsibility, and you have to act according to public trust doctrine. Then Mr. Jayavira summarized the history with regard to regularization of media, and he pointed out that in terms of electronic media, we have only two acts that is Sri Lanka Broadcasting Corporation Act and the Sri Lanka Rupavahini Corporation Act. And the next session, the last session of our conference, Balancing Digital Rights and Social Interests. I think we had a very interesting session under this topic, and we try to recognize certain basic ethical standards that we should employ when we are using social media, such as Facebook, and the importance of making aware the users what he's getting into when you are using World Wide Web or the Internet. So with that, I conclude my summary, and I'm sure you all had a very interesting session and a conference, and I hope that this will be a good beginning for a new change. Thank you.
So here, in addition to this, the way forward notes, that I would like to thank the collaborators and organizers of this media conference, international media support, and on behalf of National Secretariat for Media Reforms, I am very much thankful. I convey my sincere thanks to the international media support to organize this historical event in Sri Lanka, and the partners of this conference, Colombo Law Society and Sri Lanka Media Law Forum. And further to that, actually, this is the time to thank the guest speaker, Mr. W. Jafar. He is all the way coming from Indonesia, the human rights lawyer and researcher, belongs to the Institute for Policy Research and Advocacy. Our sincere thanks goes to him. And that panel members, lead speakers, and other participants for the other 4 sessions we have completed here. For them also, our sincere thanks goes to them. So this is a wonderful moment actually. So I think we have to go a very long journey. So I think it would be a very good beginning to think about that existing system and what are the changes and what are the reforms can be made to have a very constructive media environment in Sri Lanka. So thank you very much to you all for your great participation. Thank you very much.